He never gets that call to his mother. Instead, he is placed in an empty room. After an hour, Ronnie tries the door and realizes he has been locked inside. He then notices a small camera in the corner. He is being observed. For hours, Ronnie banged on that door as the room seemingly got smaller and smaller. Finally, the cops came in. At this time, they inform him that they know about the robbery at the convenience store, the one that he drove for. They know there were 2 men robbing the place, and he was the lookout and driver. They tell him he can make a deal if he gives up his 2 friends. Ronnie looks at them and waits for the punchline. What are they talking about? They try a few more intimidation tactics, but it doesn't really work. Ronnie demands to have his call. The officers relent and reluctantly allow Ronnie to walk back home. There was one cop that was responsible for accusing Ronnie of this armed robbery, and that man's name was Sonny Vogler. That's right. He was the lead detective on the Sarah Boss case. He swore Ronnie knew more about this robbery, and Ronnie had a history of working against the cops. Sonny Vogler didn't just happen to remember Ronnie during the Sarah Boss case. That's how he presented it to himself and others. But this seems to be a vendetta from when Ronnie was 15. Him and his brother teased the cops. He exposes them when they were policing the neighborhood. DC cops call with questions about Ronnie being a suspect in rape. Ronnie is set up for that robbery, but the dry run does not work. Ronnie fights at the park. Then Sarah Boss is raped. Now Sonny Vogler can finally get his man. The second time, the setup worked. I'm going to say what you should be thinking. What in the actual fuck? Why didn't Ronnie tell his lawyers? Apparently he did. They decided not to introduce this information, concerned it would simply paint Ronnie as a law-obstructing criminal with a history of violent crimes. Could this information have swayed the jury? Wouldn't it be interesting if we could track down Sonny Vogler and ask him all about this? Well, we can't. He died back in 2010. Nowadays, Ronnie is in constant pain. His stomach has swollen to the point where it's becoming noticeable, even if he's wearing a shirt. For his treatment, he gets blood pressure pills and painkillers. At times, it's a struggle just to move around. Couple that with the fact that the last conversation he had with his mother was an act of false hope and denial. Ronnie has been waiting long enough, and now some hard decisions have to be made. He makes it clear to Ashley and his lawyer that he is near his breaking point. Ronnie decides that perhaps it's time. If he goes to these classes, maybe the state keeps their word. Maybe he gets parole. Maybe he gets out before his mom dies. That's a lot of maybes. This gives a sense of urgency to Ronnie's team. After months of stalling by the state, they have had enough and decide to organize a march. On March 6, 2019, activists and protesters made their way to the Attorney General's office. In a strange turn of events, the Attorney General's office agreed to meet with the protesters. Ronnie's sister was there, and she pleaded the case for her brother's freedom. She explains that 2 of Ronnie's sisters have died, as well as his father, and his mom is severely sick. She is 87 years old, and the odds are not in her favor, but she is holding out just to see her son Ronnie go free. Another week goes by, with no word from the courts. Sooner or later, you have to accept defeat. But right before Ronnie has to betray himself with a lie, he is told the 4th Circuit Court of Appeals, based out of Virginia, will begin oral arguments for his case on March 20th, 2019. Finally, Ronnie's lawyer, family, and all his supporters celebrate this development. Robin Hayes was enraged. He makes phone calls, threats, and calls in favors, hoping to keep Ronnie in prison. But the political climate is not on his side. Why does Hayes feel Ronnie's freedom is a personal affront to him? When you take a stand or build your career on a case, that case has to remain exactly as you left it, closed. But a tide was turning in Ronnie's favor. Karma caught up to Robin Hayes. The GOP chairman was indicted in a scheme to bribe State Insurance Commissioner Mike Causey. Hayes was forced to relinquish all of his day-to-day responsibility as chairman of North Carolina Republican Party. He would no longer exert his political power to keep Ronnie in a cage. Good riddance. They now need the court to see that keeping all the evidence hidden did affect the jury's ability to judge him fairly. Remember that Brady violation? 3 judges will decide. 2 white men, Judge Paul Victor Nehemiah, 79 years old, and Judge Julius N. Richardson, 44 years old. And then there's one female judge named Stephanie D. Thacker, 55 years old. They will not so much look at other factors like the jury tampering, his alibi witnesses, shaky victim testimony. Sarah's thinking Ronnie was light-skinned. But as to whether or not all the exculpatory evidence like no paint or carpet fibers on Ronnie, questionable footprints, matches at the crime scene not matching the ones in the Long family car, missing rape kit, dozens of fingerprints found at the scene, none of which matched Ronnie, and the 2 other suspects. If they believe this new info would have gotten Ronnie a different verdict, then they will open the door for his justice. The 2 sides both present their arguments.
Long versus Hooks, and Mr. Lau, whenever you're ready, we'll hear from you.
May it please the court, Your Honor, Jamie Lau on behalf of the appellant Ronnie Wallace Long. The issue before the court is whether the state MAR court unreasonably applied clearly established Supreme Court precedent when determining that the favorable suppressed evidence considered cumulatively was immaterial. The Supreme Court has said whether evidence is material depends on if in its absence defendant received a fair trial, understood as a trial with a verdict worthy of confidence. Here, in light of the suppression, there's no reason to have confidence in the verdict. The suppressed evidence was strong evidence pointing away from Long as the assailant and towards a mistaken ID by the victim. It revealed that officers testified falsely and a misleading way at Long's trial and resulted in arguments from the prosecutor in closing that are now known to be unsupported by the evidence. This case is very much like the Barbie case from the circuit because law enforcement officers suppressed the evidence not only from the defendant, but also from the prosecutor. The prosecutor, Ron Bowers, testified in the state MAR hearing that he didn't have the evidence that was suppressed in this case because he didn't know about it from law enforcement officers.
Before we get to what I understand the meat of the argument and what I primarily want to focus on, help me understand a little bit of the framework that we're in. 2244B2, which is the sort of framework, I think, given the successive habeas petition. Do you agree that is a jurisdictional requirement for the district court?
Yes, we have to meet the requirements under 2244B2 to show that by clear and convincing evidence, no reasonable juror would have convicted Long but for the constitutional error.
And here what we had, in essence, they're basically like two important parts of that. We could call it 3, but I'll call it 2. And 1 is that there is a constitutional violation. And 2, that but for that constitutional violation, or with the addition of the evidence that was suppressed, in this case, no reasonable jury would convict.
That's correct, Your Honor. And
the district court below, magistrate judge, but adopted by the district court, addressed only the first issue, right? That is, was there a constitutional violation?
That's correct. The district court.
And so I just want to, it's just framework. I think these are easy, right?
Yeah.
So if we agreed with you that the district court got that wrong, and I'm not at all suggesting that's the case, the result for that would be to send it back to the district court to determine this second part, which is no reasonable jury could conclude that he was guilty.
That's correct, Your Honor. Or on the record, given that it's a state court record that's before the court, I believe that the facts here are so compelling that this court could decide the jurisdictional issue with the facts in front of it, but definitely it has to be determined before the merits of the case can be decided in this case. This case, similar to Barbie, is a due process violation in that this powerful evidence was suppressed from the defendant. And in Barbie, this court said we cannot condone the attempt to connect the defendant with the crime by questionable inferences which might be refuted by undisclosed and unproduced documents then in the hands of the police. This procedure passes beyond the line of tolerable imperfection and falls into the field of fundamental unfairness. This is precisely what this case is about. The police cleansed the record of evidence pointing away from Long to ensure that he was convicted on the basis of a weak, flawed identification. To do this, officers took extraordinary...
You make that claim there, and you make it a number of times in your brief, that this was, they cleansed the record, that this was a conspiracy to convict Mr. Long. Tell me why. I mean, I get the idea that you believe that's a necessary part of your story. Otherwise, I wouldn't be hearing it so repeatedly. Why is it that a mistake in your mind wouldn't be sufficient, right? So if these officers just simply made a mistake, and I'm not hypothesizing one way, but if that was the finding, why wouldn't that be enough to satisfy your burden?
The mistake would be enough to satisfy the burden because false testimony was introduced at the trial, and whether or not that false testimony was introduced intentionally doesn't change the fact that it was false. Of course, there's much more here, and that's why we describe these acts as intentional.
What was the false evidence?
The officer testified that there was only a single item or two pieces of evidence that was brought to this SBI crime lab. A latent shoe print that was taken and collected from the crime scene, as well as prints from known shoes that belonged to Long. He then testified that all the other evidence remained in his possession throughout the course of the investigation, never left his possession. The true facts are that 13 additional items of evidence were brought to the State Bureau of Investigation crime lab. They were believed to be probative of the perpetrator of the crime, and all the testing that was done on those items of evidence by the State Bureau of Investigation crime lab indicated no connection between Long and the crime.
They just were negative, right? They didn't exclude him. Like the absence of evidence is not evidence of absence.
Well, they were negative, but...
A leather jacket that doesn't have paint flakes on it. They explained, well, leather doesn't hold paint flakes very well. And so they never reported the fact they didn't find paint flakes on the leather jacket. The fact is, there's nothing exculpating and nothing inculpating. So, and that was most of the evidence that they addressed. And I know it can be cast in different light, and your argument is, well, we could have graded that in front of the jury to say there was nothing there to inculpate. Well, it's a little bit like finding a lot of items around the scene of a crime and no fingerprints are lifted. That doesn't exculpate or doesn't inculpate. So I'm just challenging the importance of it. You're elevating very high, and there has been no challenge to the identification evidence, which was, I think, lineup evidence is terrible evidence, but this is a matter of abstract. But this identification was much more carefully done, and the defendant was much more sure of herself in what she was doing. So the jury heard all that and made I'm sure that was a big item of evidence.
2 points, Your Honor. With respect to the evidence pointing away from Long as the assailant, it does have a powerful impact because
why did it point away?
It pointed away because law enforcement officers believed it to be probative.
No, they just collected the evidence around him, and some of it 2 weeks later. From his car.
They collected several items of evidence on the night of the crime. Right. Those items of evidence were collected from the victim. They were collected from the crime scene, and they were also collected from Long later on. And that evidence collected from Long was evidence that was used as standards to compare to the evidence collected at the crime scene. The evidence collected at the crime scene included a hair that was believed to be hair probative of who was the individual who commissioned the crime.
Why would you say that? That's the type of jump that doesn't work. They find a hair near the scene of the crime. That hair could be from one of 100 people. And the question is, it's only when the hair matches somebody, right?
Well, the hair has the negative result has powerful implications on all the evidence they collected.
And they never turned any of those negative